Hello and welcome to this podcast. My name is Catherine Wilson and I'm a partner in employment law with Constantine Law, and today I'm joined by my colleague and senior associate Ellie Rogers. The aim of today's podcast is to focus on the area of data protection in the area of recruitment, and particularly external recruitment. Often this is commonly known as the 2018 General Data Protection Regulations, or GDPR for catchily short. And the GDPR was originally a European directive which aimed to legislate and control how organisations use personal data. Now, notwithstanding our exit from the European Union, but in recognition, I think, of the very close ongoing ties and the number of cross-border institutions and businesses, the last Conservative government decided that they would maintain compliance with the GDPR in our own domestic legislation. I think it's also worth pointing out at the beginning that this is not a new piece of legislation, and in fact we've had protection in relation to data protection for many years, going all the way back to 1998. So the first question we're going to look at really is, what is GDPR, and really why does it matter in this recruitment space? Well, as HR professionals, you will all be very familiar with the consequences for GDPR and employees. This can include requests for data from individual employees, sometimes known as the dreaded data subject access request. And we see this increasingly used, as I'm sure Ellie will agree, in the context of grievances and particularly employment tribunals. What seems to us to be less well known is this whole context of how does this legislation work with individuals who are not yet employed by you? Well, clearly in the course of recruitment, employers and of course HR professionals will handle significant pieces of personal data relating to would-be employees and candidates. But both Ellie and I felt that responsibilities to those individuals can be overlooked, and certainly they're a lot less well known than our obligations in other areas of data protection. So hence why we decided we'd do this podcast. So I said at the beginning that in some respects this is nothing new, but there are some significant changes with GDPR which you need to be aware of, and I want to highlight these at the beginning. The first is that there is a strengthening of individual rights and a corresponding greater obligation on the part of the organisation, on the business, using the personal data. Similarly, for those cross-border businesses, bit of a tongue twister there, there's obviously a need for greater commonality and consistency of regulations across the UK and Europe. There are different considerations which are really beyond the scope of our podcast today to deal with data sharing across the Atlantic. But suffice to say, really to emphasise how important it is that for those of you who are regularly sharing data with North American colleagues, that they are aware of their regulations in this regard. So before we look at the question of what is data in more detail, perhaps, Ellie, you can tell us the three things you think employers need to know about GDPR.
Thanks, Catherine. So first of all, you have to have a legitimate reason for processing data, and that is based on a reasoned basis and that the processing is necessary in the circumstances. You have to have consent from the individual, and that has to be given freely. So in the context of recruitment, there's sometimes a little bit of a question mark as to whether the individual is freely giving their consent or not. The consent needs to be unambiguously given, so we have to be really clear and careful that we have their consent. But equally, if the individual chooses to withdraw that consent, they can do so easily. The consent has to relate to the purpose and procedure for which the data is being used. So make sure that the consent you have is in line with your requirements as a business. So Catherine, what types of personal data could arise during a recruitment process?
Well, I think the first place to start with this is that personal data is any information which relates to an identified or identifiable natural person, called a data subject in the jargon. And there are several examples of data that can be used to identify people, so they fall within this category of personal data. So, names, addresses, email addresses, telephone numbers, family details, information about lifestyles and hobbies, education and training, employment data, previous employers for example, financial information, and online identifiers such as IP addresses and cookies. And these are all really useful pieces of information. And the good news is that they can all be processed. But as Ellie's just pointed out, they need to be processed by you as the would-be recruiter in accordance with these GDPR rules. So in addition to these bits of information, there are other bits of information which are quite specific and which you need to be particularly careful about processing. So the start point is that you shouldn't process the following things without express consent. So these would be racial, ethnic data, political opinions, religious or philosophical beliefs, trade union membership, generic data, biometric data, health data, sex life, sexual orientation. You can use this information, but it's only in very limited circumstances, and it must be, as Ellie's already said, with express consent. So what would be some of the reasons where you could use it? Well, one would be clearly we need to understand gender and sex if we're going to do gender pay reporting, or indeed vital interests of the individual necessary to meet their health needs, particularly in an emergency situation. But the start point is we shouldn't process them unless we can find one of those exceptions or rationales. So turning from different types of data, obviously I think it's important that you appreciate the sort of data protection principles that govern your activities in this area. So Ellie, do you want to take us through what we think those main principles are?
Absolutely. So there are 6 main principles. I'm not going to go through them in detail today, but the first principle is lawfulness, fairness and transparency. And transparency really does underpin the whole of GDPR. We need to be really clear about the reasons and getting consent and so on and so on. The second principle is purpose limitation. So if you get consent for one reason, that's the only reason that you can use that data. For example, if you want to keep someone's CV on file for some vacancy in the future, you would need to get specific consent for that as well as processing the data in terms of the original application. The third principle is data minimization. So this really is a question of less is more. We only want to collect data that we genuinely need, and we need to make sure that it's then processed in line with those requirements. The fourth principle is to do with accuracy. So we need to ensure that if you have data on file, that it is up to date. If you realise that for whatever reason that information is inaccurate, it needs to either be erased or rectified ASAP. So on a practical basis, you may have an email address in your privacy notice so that individuals can let you know really easily and quickly if their data is incorrect. The fifth principle is to do with storage limitation. So this really is about how long you can keep data. You can keep it no longer than is really necessary for the purposes that you have in mind. So for example, with someone in recruitment, maybe you would keep the information perhaps for 6 months, bearing in mind limitation period is generally 3 months. It really would depend on the circumstances. So, but just to give you the idea. The sixth principle is to do with integrity and confidentiality. We need to ensure that that data is kept confidential and is used appropriately. So we have to have security and processes to ensure that that information is not misused, lost or damaged in any way. And particularly in terms of special category data, we need to make sure that that absolutely is kept confidential. So I've kind of given you some examples of how we look at this in terms of recruitment, but Catherine, can you give us some more information about how GDPR is relevant in recruitment, please?
Well, as I said at the beginning, I think we're very focused on GDPR in the course of employment and how we deal with our current staff, but I think we are less interested, shall we say, or certainly less focused on how it implies in the recruitment process. And at the beginning, I really want to acknowledge the fact that we often don't control that whole recruitment piece. So I'm thinking about the increased use of online job sites, LinkedIn, and of course recruiters and headhunters. I think it's particularly important, as an opening remark really, to say that if we're using third-party providers, we must make sure that they are compliant with their duties under GDPR, and they may be slightly less compliant and knowledgeable than you might imagine. I definitely think it's an area of expertise that you would be worth testing, shall we say, as part of the appointing of recruiters to help you. But some of the other matters, I think, are this acknowledgement that a candidate whether internal or external, are data subjects for the purposes of the GDPR. They're clearly identifiable. They give you a lot of personal information, names, addresses and phone numbers, so they fit the definition. At the same time, employers and or recruiters acting on behalf of those employers determine the purpose of collecting the candidate data, and that makes them the data controller. So as data controllers, under the general principles that Ellie's just talked about, they are fully responsible for protecting that candidate data and using it lawfully. So, 3 very important points. Ellie's already touched on this issue about legitimate interest to process the candidate data, something more than speculative. And also about having the candidate's consent to processing that data. Express concern definitely preferred, but rarely asked for in practice. So Ellie's going to talk about privacy notices and the like shortly, but I think I would just flag that at this stage. And the other thing as well, as Ellie's already said, is you have to be transparent about the processing of the candidate data. What are you doing? Why are you doing it? And how long will you keep the information for? So, Ellie, any other areas you think employers need to specifically consider?
Well, we've talked about data minimisation, as you just said, and privacy notices. I have come across quite a few clients who don't have any privacy notices specifically for recruitment. So I think it's really important to make sure either you're sending out your privacy notice or have a link to your website where you're absolutely clear about what you're going to be doing with that data. Going back to data minimisation, I think this is really key. You might want to think about sequencing questions. So you don't really need to ask for somebody's or evidence of somebody's qualifications right at the outset. Perhaps you ask that question when you're giving a conditional offer. And particularly, I think we always need to be really careful with special category data, so sensitive information. One of the things that I come across quite often in practice is details about health and reasonable adjustments. So making sure that we put in place ways and means of ensuring that the individual's data is protected, but also making sure that we can comply with other duties. So, for example, with reasonable adjustments. Catherine, from your perspective, are there any other areas that you think are particularly relevant?
I think there are, and we've obviously focused about the candidate experience and when they first apply to you, but I think there are other areas as well. So one would be, self-evidently, we need to take great care that the adverts are legally compliant and we don't simply use something we've used before, because obviously that raises a number of particularly tricky issues as things have undoubtedly changed. But the other bits I think that are relevant, particularly in this GDPR context, are one is interview notes. How long do we keep them for? Why do we keep them? I mean, clearly, self-evidently, they're a memory jogger, but I think it's really important for people to realise that if we keep them, if there is a subsequent claim, then it will be very difficult to defend without those notes. And unfortunately, you do still see what I can only describe as rather unfortunate remarks about candidates. The classics to me are, is she wearing an engagement ring, or she was the plump fat one? So really would prefer not to have those types of notes put forward. I'm sure they would have been better shredded, but that would not have been compliant, because we collect and we collate these records and we store them. Don't forget the candidate has the right to see them. And I think people do often forget that candidates who have not started work have still got protection, particularly if we're looking at the Equality Act. So I think that's a really key area.
Absolutely.
Another key area, I don't know what Ellie thinks, but I think is about this handling background checks and references. We need explicit consent from candidates before we conduct those background checks. We also need to be clear about why we're doing those background checks. So, for example, blanket credit checking sometimes seems to me to be a bit OTT. Might be appropriate for a financial position, but I'm not sure how appropriate it is for other provisions. I think the other thing we also need to be clear in terms of the referencing generally is who is going to be approached. What's the difference between a personal reference and a company reference, for example, and when are they going to be approached? Because clearly individuals who are still in work get quite nervous if their employers are approached before they're actually offered the job. I do think it's also important, if we look at referencing, that we make it crystal clear what references we want, and that in particular that we as the employer will decide whether or not those references are acceptable. So it's quite a subjective standard. I'd also suggest that we make it time limited. So if a reference is not received, which is acceptable within a certain time scale, then at that point offers will be withdrawn. Because again, I think increasingly we do seem to see a lot more of that as part of this whole ghosting type process. So very important as well to handle the personal data of the referees with care, because they have the right to have their data handled in accordance with GDPR as well. And then the final point really I wanted to flag is this whole question about a job offer, making sure that information that's received is confidential. And as Ellie's already said, I think there are particularly tricky issues in relation to health conditions. That would probably be a podcast all of its own. But suffice to say, I think the general rule is not to simply withdraw if something comes back on the health questionnaire that you're surprised by, shall we say. I think it's always worth discussing with the candidate. I think it's always worth trying to seek further information and offering reasonable adjustments, as Ellie said. However, I acknowledge that these may not always be possible. So withdrawing the offer, do explain the reasons to the candidate. I think the other points I wanted just to flag really as sort of closing remarks are that prevention is always better than cure. The ICO guidance is actually very good, not just as a cure for insomnia. It actually comes up with a lot of practical stuff. Very important to ensure that your internal data protection policy and systems cover the area of recruitment, and also ensure that they're freely available and regularly updated. As we all know, like cheese, non-updated policies go off in the fridge and become fairly useless.
They do,
but
indeed.
I do think that they do raise several issues. If nothing else, find out who in your own organisation is actually responsible for data protection issues, because I think that can be a very useful starting point. And then the final thing I wanted just to touch on was this whole concept of the impact of AI in the area and automated processing. Again, probably a podcast all on its own. Again, very important to have the express consent of the individual. There's also a lot of care, I think, needed in terms of scrutiny of the SIFT and making sure that there's no baked in or implied biases. So, Ellie, anything else?
Well, I suppose we probably wouldn't be doing a very good job if we didn't look at the consequences of getting the GDPR wrong. And actually recently I've been looking at the ICO website, and there do seem to be more and more fines issued by the ICO. So for example, just recently a company was spam calling for a period of time. They spam called 95,000 people, and they just received a fine of £90,000, and they couldn't provide any evidence that they had the individual's consent to call them. Another example is a software company recently has had a £3 million fine, and a law firm had a £60,000 fine. As I say, the ICO can issue a fine or penalty if the company is found to be in breach. So that can either be the higher of 4% of global annual revenue or up to 17.5 million, dependent on the severity of the breach. So the ICO will look at various things. So, for example, the nature of the breach, the gravity of the breach, the duration, and also the action taken by the company in order to prevent that breach. It will also look at the level of damage suffered by the individuals. And this is in addition to compensation that the individuals can be entitled to for damages. I mean, I think back in about 2020, there seemed to be very few fines coming through from the ICO. But that seems to have upticked, and also in terms of reprimands from the ICO. We've seen local government, for example, being reprimanded for not dealing with subject access requests in a timely manner. My perception from practice is that individuals are absolutely aware of their rights now in terms of data, and much more. We're seeing individuals coming to us and saying, I want to put in a subject access request, whether it's just in terms of recruitment or when the employment relation comes to an end, and also sometimes during employment. So I suppose taking away from that, it is an important something that we need to consider and get it right. Otherwise, the consequences can be pretty grave.
Thanks, Ellie. I mean, I think the other thing I would add to that, of course, is apart from the money, there's also the reputational risk.
Absolutely.
Of being named and shamed, which clearly can't be particularly great for business. So we hope you found this podcast helpful. We would really welcome your feedback and, of course, any ideas that you might have as to topics for other podcasts going forward. But thank you very much for joining us today.
Thank you.